Again, good afternoon and welcome to the Housing Accountability and Production Office Open Forum. Excited to be here with you all this afternoon. I'm Joel Matson. I'm the manager of the Housing Accountability and Production Office, or HAPO, as you may hear referred to this afternoon. I'm going to hand it over to my colleague Kieran to share some housekeeping with us here before we dive in.
Yeah, thanks, Joel. And yeah, thanks everyone for attending. So since the webinar is over 100 people, we can't do a standard Zoom meeting for this call. So for Q&A purposes, we'll stop periodically during the presentation to answer any questions you might have. And there's kind of two functions that you can use to ask questions. One, you can use the little Q&A function at the bottom of your screen. And if you press that button, you can ask questions and they'll be cataloged and logged there, and I'll make sure to keep track of them. So whenever we stop during the presentation, we'll answer those. And you can also raise your hand and then we can unmute you manually to ask a question if you want to do that verbally. And then also we'll share materials and slides at the end of the webinar with a follow-up email. So don't worry about trying to keep track of links and everything as we go along.
Yeah.
And I'll pass it off to Mari for the May 22 webinar announcement.
Sounds good. I do see Ethan came off mute, so maybe it's a first handoff to Ethan and then maybe a support to me. So Ethan, please.
Thanks, Madi. Hi, everyone. My name is Ethan Sugmeyer. I manage the housing division here at the Department of Land Conservation Development. Just wanted to share with you all, we're coming down to the end of this current biennium, the 23-25 legislative biennium or state biennium, but we're opening up a new one, coming upon a new one, the 25-27 biennium. And with the new biennium becomes new grant opportunities for local governments to engage in Goal 10 housing planning work. So the May 22nd webinar is to have an initial conversation with local governments who might be eligible for those grants to talk about the specifics of what projects are eligible, what the time periods are, what the dollar amounts are, so on and so forth. So definitely encourage you all to attend that webinar if you're interested in seeking state grant dollars to conduct housing planning work in the next biennium, in the 25-27 biennium. And I'll hand this off to Madi if you want to share any more specific details.
And hi, everyone. Madi Valencia Aguilar, Cheer, they pronouns. I'm a housing planner within Ethan's team in the housing division. And I'll just say that maybe put some voice to some of these pieces on the slide, which is the housing planning assistance. Currently, we have allocated 3.5 million for local housing planning work related to housing, and it could potentially increase depending on the legislative session right now. We are planning for a 2-month application period starting June 2nd through August 1st. And folks who can come into the division for planning assistance, it is wide. It includes local governments, cities, counties, tribal governments, and regional entities. And then, as Ethan said, the focus here is Goal 10 planning and Goal 14 urbanization housing related work, as well as code work and housing planning work that supports the tribal governments. So that's all within the scope of our planning assistance. And then we did put the link in the chat so you can sign up. And we'll also, if you can't make it, and in particular local governments, we, like the HAPO, we do have an open forum planned June 2nd at the start of our application period, where we'll overview at a high level what we discuss on May 22nd. But on May 22nd, it will be recorded, so there will be opportunities to continue to learn about the process and our timeline and get in some of the questions and answers that we provide to participants. But then also, again, June 2nd, if you want to see us again, specifically the full housing division whom is not fully here, we'll be at the open forum. So with that, thank you for the time, HAPO team, and maybe I'll hand it over to Sean.
Likewise, thank you, Mari. I'll actually pass it back to Joel, who I believe is kind of kicking us off or setting the stage for today's discussion.
Thanks so much. And again, good to be with our colleagues at the Housing Division here this afternoon with you all, and look forward to these future opportunities for collaboration. The HAPO Open Forum, here we are this afternoon. And again, thank you for joining us. We will continue these open forums every other month, kind of alternating as you heard about the upcoming webinar, but the next open forum, first part of June, will be focused with the Housing Division. July, HAPO Open Forum will be back. So please keep subscribed and paying attention to these open forum and opportunities for engagement. Before we dive in further this afternoon, I want to take a minute to recognize other members of the HAPO team and those that we're working closely with through this initiative, and allow a brief opportunity for introduction. So again, Joel Mattson, the manager of the Housing Accountability and Production Office. And I'd like to hand it over to my colleague, Lauren, to do a brief intro.
Good afternoon, everybody. My name is Lauren Drossen. I'm also with HAPO, and my role is the lead housing navigator, so focused on helping developers and local jurisdictions navigate state processes, funding opportunities, and general guidance.
Great, thanks, Lauren. Kieran?
Hi, everyone. My name is Kieran, and I'm a housing navigator alongside Lauren. Nice to see you all.
Thanks, Kieran. And Sean?
Hi, folks. My name is Sean Edging, a housing planner at the new HAPO. Oh, we also, Joel, it looks like we're getting a little bit of a question to describe our experience or qualifications in housing development or in local government. Just for my background, I've been working with DLCD for 5 years on the implementation of various housing laws, including middle housing, the Oregon Housing Needs Analysis, and before that, I worked in the private sector on housing development related applications.
Great. Thanks, Sean. And Ryan?
Hi, good afternoon, everyone. Ryan Markwart, and I am a housing planner with the LCD and part of the HAPO team. And as far as a prior experience with housing development, I spent 17 years as a local planner in Oregon with City of Milwaukee and Washington County, and was in the City of Staten as a rare participant before that, but that's going back a ways. But yeah, that's kind of my brief overview of land use and housing history for me.
Thanks, Ryan. And Rachel?
Hi, everyone. I'm Rachel Six. I'm a housing planner with HAPO. I've been with DLCD since March of 2023. My background is actually in natural hazards planning. So I spent the last 2 years working with our state NFIP coordinator, helping local jurisdictions manage their floodplains in compliance with the NFIP.
Thanks, Rachel. And Emily?
Hello, my name is Emily Anderson. I am the administrative specialist with the HAPO team. So I just provide various types of support for the team needs. My former experience is in the private sector, working with a construction company, doing admin related work. So just excited to be here.
Thanks, Emily. And Palmer?
Thanks, Joel, and good afternoon, everyone. I'm glad to see you all tuning into this webinar. Appreciate that. So Palmer Mason, Interagency Coordinator. I'm actually in the director's office, but I work closely with the team at HAPO, and my role is to work on bringing state agencies together to look at housing production barriers and opportunities to leverage state resources to maximize housing production. My experience is going on 17 years in state government, mostly in roles around government relations, policy, legislative work. I've been at DLCD for 6 years.
Thanks, Palmer. And as this is a joint office with our colleagues at Building Codes, I'd like to hand it over to Tony for introduction and to introduce your teammates that you have with you as well.
Yeah, thanks so much, Joel. Good afternoon, everybody. Tony Rocco. I'm the Housing and Building Safety Manager and also the Structural Program Chief here at the Building Codes Division. I've worked in the construction industry in Oregon for the past 25 years. The last 13 of them have been at the Building Codes Division. I've been in the Structural Chief role since 2017. And I have Andrew Bolton with us. Andy, I'll turn it over to you.
Yeah, thanks, Tony. I'm Andy Bolton. I'm a senior policy advisor with the Housing and Building Safety section of the Building Codes Division. I've been with the division for 5 years now, all in policy type roles. My only housing experience prior to that was working on programs for building housing after disasters. So mostly Sandy related.
Great, thank you, and thanks for allowing the opportunity to meet those of us that are working closely on the HAPO initiative here. I'll share. So I come to this role with leading a regional public housing authority for the past 10.5 years, and serving a variety of rural and more urban communities in that role, and really focused on housing production for lower income households in that role. I've spent the rest of my career in housing and other areas of the industry, and really look forward to being part of the HAPO team that's charged with helping to boost housing production across the state of Oregon. This afternoon, what brings us here is a really exciting milestone for our team, where we get to introduce 2 of our kind of core policies and procedures that our office will be focusing on here in the coming months. And I want to also just acknowledge, thank you all for your interest in showing up here, despite not necessarily having a bunch of materials to review prior to this open forum, and really just want to emphasize this is the first of what we hope are many opportunities for engagement with interested parties around the state. So this afternoon, we'll do a brief overview of our office. We'll dive into a little bit more specifics of those policies and procedures, and then we'll allow hopefully plenty of time for discussion and questions at the end. Next slide, Emily. So the Housing Accountability and Production Office was created out of Governor Kotek's housing production package, also known as Senate Bill 1537. And our purpose is to support developers and cities to boost housing production. Our approach is that of collaboration first, and in those hopefully rare circumstances, enforcement last. Our office is focused on ensuring that local land use codes and decisions meet the state laws. We are also excited to be there providing technical assistance and funding in collaboration with our local government partners. And our office focuses on research and guidance to reduce barriers to housing production. Another core focus of our office, next slide please, is in the interagency coordination. As we mentioned in our introduction, our office is jointly managed by DLCD and the Building Codes Division. And we're excited to be leaning into enhancing agency coordination across the housing development cycle. We are working with the Governor's Office to develop more of a focused interagency framework, again, that's aligned toward boosting housing production. Next slide, Emily. And actually, I wanted to share a couple of things about what else we've been up to. So maybe go back 2 slides, if you don't mind. One of the focus points of our office has been helping to navigate the scope of work and ultimately the request for proposals that we'll be issuing for what we've referred to as the Section 5 reports of Senate Bill 1537. These reports are intended to identify how the standards and procedures used in land use planning, the entitlement processes, and public works approval could be approved to reduce costs, minimize delays, and generally increase housing production. Another part of this report that we're working on is to produce a summary of state agency plans, policies, and programs related to reducing or eliminating regulatory barriers to the production of housing. Again, I wanted to emphasize this is we will be working on these reports over the next 12 months or so. with the goal of reporting back to the legislature in September of 2026. And we look forward to interested parties engaging in these reports and studies as we move forward as well. Obviously, it's taken a bit to staff up our office since HAPO was created. That's been a focus of ours, and you see the full team here represented this afternoon. We've also had the opportunity to respond to informal inquiries over the past few months, working with both developers or local jurisdictions that have been requesting technical expertise from our office. And then another highlight I just wanted to mention is there was an opportunity through Senate Bill 1537 for local jurisdictions to request exemptions to mandatory adjustments or design and development flexibilities to the housing applications. So our office has been navigating those requests for exemption. And I'll ask a colleague to put a link in the chat where you can track more closely the status of those requests for exemptions and where the mandatory adjustments are playing out across the state. And next slide. I wanted to highlight kind of where we're at, again, as an office, really introducing these core policies and procedures this afternoon. And we hope that during the month of May, we'll be able to receive plenty of feedback through email and other venues, and encourage you to ask questions of our office. You can see here the HAPO email address that we'd ask that you communicate with us through. And our operational date is July 1st. So all of this is leading up to that first part of July to being officially operating in our capacity. This afternoon, we're diving in more specifically to our process around how we'll navigate inquiries and providing that informal guidance. Also how we'll be navigating a more formal housing law complaint, and more generally, helping folks that reach out to our office to navigate some of the other complexities of housing production. The other focus this afternoon will be on our technical assistance program. Again, the purpose and scope of the funding, priorities for investment in partnership with local governments. I believe I'm going to hand it over to Ryan to dive in a little bit deeper here.
Yeah, thanks, Joel. Good afternoon, everyone. And I'll be kind of presenting the inquiry portion of our policies and procedures. So to start off with, this is kind of an overview of the different types of inquiries we expect HAPO will be receiving. Part of this slide kind of speaks to the fact that HAPO has several different functions assigned to it by the Senate Bill 1537. And so as we receive inquiries, we're going to be kind of grouping things into these categories so it can be assigned to the appropriate staff for review and response. So just as a general overview here, the inquiries that come in, we're expecting some of these to be informal guidance with regard to land use and building code inquiries. So those are kind of those two things over on the left-hand side of the screen. And then there's kind of a formal housing law complaint process that I'll get more into in a couple of slides, and that's something that's specified and kind of prescribed within Senate Bill 1537. And then over on the right-hand side is the navigation portion of things, and Kieran will be presenting more information on that portion of things. But this is just kind of a general overview of the inquiries that HAPO expects to be receiving as we're getting operational. Next slide, please. So generally, the goals that HAPO has for responding to inquiries, in the materials that were posted on the website related to the policies and procedures, there are a lot of specific steps and detail there. There's also kind of an explanation of some of the broader goals that the office has for reviewing and responding to things, and those are presented here on this slide. And some of the rationale for those is explained a little bit more within that document. But these goals kind of cut across. They're not specific to any particular category or any one review process step. They're really kind of broader procedural goals and the way that we kind of want to operate and handle things. So that's sort of the purpose of having these overarching goals of guiding us in our response to inquiries and how we review and respond to things. Two that will kind of come up in the slides that I'm going to be presenting on in a little bit more detail are the second one of seeking to resolve issues through early informal engagement, and then also the third one of prioritizing voluntary compliance. So those will kind of be themes in a couple of the slides that I'm going to be speaking to. Next slide, please. So one thing that's important to note about HAPO and the things and issues that it can review and respond to is when I had said housing law violations, there's a very specific definition of housing law within Senate Bill 1537, and that's kind of up at the very beginning of the Senate bill. And it says housing law is defined as, and then has a list of several different sections of the Oregon Revised Statutes, and by reference the OARs that implement those statutes. So, and Tony, I was going to turn it to you to kind of talk about the building code, housing law side of things there.
Yeah, absolutely. Thanks, Ryan. So on the building code side, there are many references throughout ORS 455 that are included. And we put a few examples here in front of you all on the slide. And so we start out with permit and plan review timelines and applications associated with permits. So your permit applications, all submittal requirements associated with that. Construction document and submittal document requirements. So again, what accompanies that permit application set locally. The Oregon Residential Specialty Code obviously covers housing, and that's primarily the code that we think about when we hear the term housing. But then we also have housing included under the OSSC, or the Oregon Structural Specialty Code. That includes multifamily housing. So both of those codes, we're really looking at the application of those. Cite it, write it rules. We have rules associated with that. So anytime that there's a correction made, whether that be during plan check or out in the field during inspection, the actual violation or the provision in question must be cited directly with adequate information to help the customer kind of understand what that provision is and how it applies. And then finally, just a few examples of things that are covered by the code. Of course, structural design requirements, fire and life safety requirements are paramount, and then accessible design requirements where applicable. And that's, 4 or more dwelling units within a single building. Hopefully that covers them well, Ryan. I'll toss it back to you.
Yeah, thanks, Tony. That's a great overview. And Emily, could you actually go back to the prior slide? Sorry, thanks. And on the land use side of things, those are all of the points that are listed there are pretty commonly understood to be land use, housing law related things. So there are a lot of parts of ORS 197 that are included. I think the entirety of ORS 197A regarding housing law is in there as well. So the clear and objective standards is obviously a big one, as well as middle housing, ADUs. So many of the things that are listed there are pretty commonly understood to be housing law, but again, those are specifically defined within the Senate bill. And for HAPO to be able to review and respond to those in an official capacity, they do need to be to fall within that definition of housing law. Just by example of something that can be residentially related that HAPO wouldn't be able to respond to. For example, the Oregon landlord tenant law in ORS 90 certainly affects a lot of residential situations, but that is not something that falls within the definition. And so HAPO wouldn't be able to officially review and act on anything that was related to that statute. So next slide, please. Okay, so this is kind of the more of the details about the informal guidance and complaint flow chart that I'm going to spend a few minutes going through here. So on the prior slide, I kind of noted there was the informal guidance for building code and land use in those two boxes that were on the left-hand side. And that's kind of what I'm going to speak to there is related to that informal guidance row that's sort of above where it says informal guidance in that green box. And then the kind of as a counterpoint to that, the housing law violation that's more kind of specified and prescribed by statute in Senate Bill 1537 is kind of that middle path there where it says housing law violation complaint. So those are kind of the two processes, and both of these are explained in a lot more detail in those materials that were posted on the website. And we know that people haven't had a lot of time to review and digest those. So this is kind of more of a high level overview and orientation of those processes, so that as you're kind of diving into those details and giving feedback and to HAPO on the procedures and developing questions, that you have kind of the framework for how these things are generally operating, and then can kind of dive into the details from there. So that's kind of the overview on what's going on here with this slide. So the informal guidance process, I should say both of these are starting out with inquiries from the outside of HAPO about development or codes. And that informal guidance process is something that can apply to either building codes or land use law. And the basic idea there is that either a housing developer or a local government may have a question about the interpretation or applicability of statute or rule, or perhaps the codification of those within a local zoning code, and how that may apply to a development project. And the idea with the informal guidance is that it's something that can be taken in fairly quickly by HAPO and reviewed, and then given a response to in an informal manner, and something that can be done in a fairly rapid fashion. One of the things that's important about that informal guidance route is that it is kind of a quicker review, and that will help projects get the information that they need to be able to continue on through the review and permitting process in a rapid fashion. Because again, the HAPO is really trying to move things through a review and expedite where possible. So where we can kind of highlight through informal guidance solutions, that's what we're trying to do. So we really do, kind of consistent with those goals, we want to rely on the informal guidance process whenever possible, because it is that kind of faster route, and we're able to more nimbly provide assistance. Another really important part of that informal guidance is that it's kind of it can kind of head off things becoming housing law violations that need to go through the other process. So if there's a question about a specific development project, for example, and we notice as part of providing informal guidance that there's some part of a zoning code that is not in compliance with state law, we can interact with the local government and kind of notify them of that issue, and at that point kind of have the opportunity to either apply state statute directly to avoid violation issues, and also to kind of be able to highlight things that HAPO and the local government can work on, and provide technical assistance for getting code amendments to remedy the situation long term, so that things don't continue to be problematic where there is a compliance issue. So those are things that are really important about the informal guidance process, and that we really want to highlight and utilize whenever we can, because it does have those benefits of being kind of quick, and also sort of being an early off ramp to avoid things becoming violations. There are situations where, however, where the compliance might not be able to be handled through informal guidance, and it could be routed to either a housing law violation through that process, or if there's a situation where a complainant knows that there's a violation that they want to have investigated through that process, that they can submit that housing law violation complaint. And that's kind of, again, that middle process on the slide. So a lot of the description within the materials that were posted on the website is very heavily prescribed by statute in Senate Bill 1537 regarding the intake, the review, the notification, and the enforcement options that HAPO has and needs to do regarding some of those housing law violation issues. So a lot of that is just kind of regurgitation of statute, but putting it in the format of kind of our policies and procedures of how we're going to go through step by step in implementing that statute. So to begin with, for a housing law violation, if there is a violation, we're going to be asking for information to ensure that the person who's alleging the violation is eligible to submit that violation as allowed under the statute, to ensure that it actually is related to housing law as defined in the statute, so that it is something that HAPO is able to review and act on. And then also just to ensure that there are materials sufficient to be able to support HAPO's review and be able to look at things in enough detail to make some sort of assessment of the situation. So that's really kind of described in the credibility review section of those procedures. And there's a lot more detail in there, but that's kind of what's contained in that portion. The second part about HAPO investigating the violation is once those materials are submitted, HAPO staff will kind of dig into the details more about what the alleged violation is, look at the proposed development, assuming it's related to a development, and also looking at what materials the local government has provided in response to that application, and going through that investigation process to really determine the facts of the case and decide whether or not it looks like a violation has been committed or is being committed. So that's kind of that middle box there. If it turns out that there isn't a violation, there's an off-ramp there where something would get where the violation would be closed and the applicant would be notified. If there is a violation found, though, that's the step, again, specified in the Senate bill, where the statute says that HAPO would issue a violation notice to the local government. And with that, it would have an invitation for being able to remedy the situation through voluntary compliance. And there'll be a slide that speaks to kind of some of those options a little bit. So again, if there is a violation, there's still that opportunity for voluntary compliance from the local government. And that's, again, something that statute prescribes as an option that does need to be offered, and something that will certainly work with the local government to get to that step if possible. And Sean will kind of talk a little bit about how some of that fits into the funding and technical assistance in future slides. If there is an escalation where voluntary compliance is not an outcome, there's some specific remedies that are listed within Senate Bill 1537, and I'll describe those in another slide here. One last thing I did want to note with the violation is a violation notice can certainly be issued as part after a local notice of decision has been filed or has been issued, but if there's situations where it's clear that a violation is going to be committed based on materials that are provided earlier in the process, that can also be the basis for a violation warning to be sent to the local government as well. So wanted to highlight that. So that's kind of the overview of the informal guidance and complaint flow chart. And the next couple of slides talk about the voluntary compliance and the other compliance options. So we'll go to the next slide there, please, Emily. Thanks. So for voluntary compliance, the Senate bill lists out 4 specific options: model code adoption, mediation, technical assistance funding or other suitable remedy, kind of dependent on the facts of the case, to be able to get to voluntary compliance. It's kind of a broad menu of options and allows the HAPO to engage with the local government and housing developer to figure out what is the most suitable option to kind of address something for a development, if that's the to be able to allow that to continue through, or for kind of long-term fixes to a development code if that's found to be out of compliance. All of those voluntary compliance options are kind of available through the informal guidance route as well. But that last point on the slide here is the voluntary compliance agreement is something that will probably be entered into if there's a violation associated with the compliance agreement. So, or sorry, with the voluntary compliance. So if there's a violation and the local government agrees to do voluntary compliance, there will likely be some sort of agreement between HAPO and that local government to make sure that that compliance is followed through on. And then the last slide that I'm going to present here is the next one on mandatory compliance. And this is kind of the last part of Section 2 of Senate Bill 1537, where it's talking about the enforcement order, court orders for building code violations, LUBA review, or a circuit court order. And as Joel had kind of alluded to, these are not options that we envision using very frequently at all, and we certainly are trying to use off ramps through the process so that things don't get to this kind of level. But if there is a violation and it can't be remedied some other way, these are the options that the Senate bill lists that HAPO can carry out in response to a violation. And also important to note that these actions cannot occur sooner than 60 days from when the violation is noted. So I know that's a lot of detail. It's all spelled out in those materials that were posted on the website in more specificity. So, and we know that there will be a lot of questions on these, probably both in this open forum and afterwards. And we're certainly here to discuss and address those and engage with folks further as we refine the policies and procedures that are out there. But that concludes the slides that I was presenting, and I think I'm handing it over to Kieran now, if that's right.
Yeah, thanks, Ryan. And so I just have one quick slide before we take a little break for some Q&A, and then we'll move into Sean's section on funding after the Q&A session. But so our office has a strong emphasis on land use law and building code law, as we're a joint office between the Building Codes Division and Land Use Department. But we also realize that housing production is a wider scope than just those two categories. So the HAPO was created to kind of be a one-stop shop for housing developers and local governments to also try to understand funding sources that the state of Oregon offers, and then also to assist in navigating state processes and requirements. So some examples for funding sources that we can help navigate, some of those are from the Oregon Housing and Community Services, which are your traditional affordable housing financing funding, but also there's a number of funding sources from different agencies across the state, such as the Department of Energy, and then infrastructure financing with Business Oregon, and also other funding sources. So we realize that it can be difficult to understand those all and navigate those all, being not an expert of those systems. So we're here to help with those as well. And then similarly with state requirements and processes, there's a number of regulatory agencies that help the housing production process, such as DEQ, and also some historic resource preservation and other agencies. So we're here to help those processes as well. And we also want to note that you can submit an inquiry to our office, and if it doesn't fall into kind of a bucket of our expertise, we're going to help you redirect that to another relevant resource or try to connect you with whoever is going to be that expert. We don't want to just necessarily hand you off or like say that it's an out of scope inquiry. We want to help you try to find a solution to what your questions are. So we're going to be assistants and have warm handoffs and try to help you throughout the process. So here's kind of like a flow chart of what that process looks like for assisting with navigation of state funding and processes and also inquiries that are out of scope. And these are also listed in the policies and procedures document, the same one that Ryan was referencing in his slides. So I think we can move on to a Q&A section. So I see we already have 2 questions using the Q&A function. So if anyone else has questions, I'm happy to also answer those by either, like I said earlier, using the Q&A function or raising your hand and asking them verbally. And I think, Ryan, I think you'd be good to answer Stefan's question if you're able to.
Yeah, and just for the rest of folks listening in, the question here, will the informal guidance process be available to jurisdictions in addition to developers? For example, if the jurisdiction wants to clarify for themselves on applicability or implementation details related to existing statutes. And yes, absolutely, that is something that HAPO is kind of doing informally currently, and certainly something that we'll be continuing to do on past July 1st. So we do want to be a resource both for housing developers as it relates to specific development applications that they're working on, and also for local jurisdictions if they have questions about, for example, like model code things with middle housing and kind of intent or interpretation questions there. We want to be a resource. So that's certainly something that is available for local jurisdictions.
And I think maybe Joel or Palmer, do you want to talk about the second part of Stefan's question related to will HAPO use these inquiries to help inform future legislative agendas, statutory cleanup where needed?
Yeah, thanks, Kieran. And I'll hand it to Palmer. Maybe Palmer, you could reference, I did kind of the Section 5 reports and our vision for those. And just want to emphasize that HAPO is not a policy-making body. And some of our work may help to inform future policy and strategies that can help boost housing production, but we're distinctly not a policy-making body. So part of our focus of our office too is to really just make the information that we're resource that we're learning ourselves more publicly available. So we want to balance that in our work and try to utilize our experiences to help overall just boost the housing production around the state of Oregon. Palmer, could you speak a little bit more to the Section 5 reports and our vision?
Yes, I can. Thank you, Joel, and thank you for the question. So Joel is talking about a particular set of reports that are required in the bill that we keep mentioning, Senate Bill 1537, the Governor's Housing Production Framework from the last short session in 2024. So one of the reports is a report that will do an evaluation of state agency programs, policies, practices around a look at opportunities to reduce barriers to housing production and to try to think about how we can prioritize state resources for maximizing housing production. That is a legislative report that will go to the legislature in September of 2026. As Joel said, HAPO is doesn't really have a prescribed role in advocating directly to the legislature on those type of changes, but we will be, of course, delivering that report, and it will outline a number of actions that agencies could take on their own volition, or the legislature could direct that would reduce barriers to housing production, and again, think about how we use existing state resources to better boost production. So That report, if it's something you're interested in, stay tuned. We'll be getting that work hopefully over the next few weeks, really, a couple of months on the outside. And that could be something the legislature could certainly look at, and the governor's office, as they decide budgets and legislative priorities.
Thanks, Palmer. I think we can move on to the next question. I see it's from Jessica. And she asks, do local governments have an opportunity to dispute a determination by HAPO that they are given in violation of a state housing law? And I think either Ryan or Joel would be great to answer that.
I can chime into that one, and thanks, Jessica, for the question. There's not a formal dispute process allowed within the statute, within Senate Bill 1537. But setting that aside, our intent is certainly that we would be engaging with the local government on anything where there is a violation, or if there's questions in the investigation about whether there is something that's a violation or we need more details. We certainly want to be engaging with the local government and kind of discussing, the facts of the case and coming up with a determination after we've chatted with the local government planners. So there's not really a formal dispute process, but there would be several points of engagement where we would be discussing with between HAPO staff and the local government.
Thanks, Ryan. And I see also there's a couple questions coming in through the chat. And just as a clarification, we do prefer that you use the Q&A function and the Q&A button to ask questions, because it is kind of a little bit difficult to navigate between the chat and then the Q&A function. And I do see we got a question about how the webinar format is a little bit difficult to navigate, and we agree. We think a traditional Zoom meeting is a little bit better, but we are unable to do a traditional Zoom meeting because we had over 100 attendees. But I do see Kevin asked in the chat, and I'll try my best to catch all these questions, and if not, we'll make sure to follow up over email after the meeting's over. But Kevin asked, will federal funding impacts affect this program? And I think Joel might be a good person to answer that question.
Thanks, Kieran. I think the specific work of HAPO is invested through the state of Oregon and resources through the state of Oregon. I think I also just want to acknowledge though the impact of federal funding and other decisions certainly do have an impact on the housing market more broadly. Our work specifically at the Housing Accountability and Production Office is funded and invested in through the state of Oregon itself.
Thanks, Joel. And we have a question from Missy. What is the relationship between these procedures and the current mandatory exemptions under consideration? And I guess maybe Sean, you might be good to answer this. And I think this is in relation to the mandatory adjustment exemptions, but I could be wrong.
Yeah, so I can speak to that. So mandatory adjustments, just for those who are unfamiliar, is a requirement that is established in Senate Bill 1537 to grant certain flexibilities to specify development and design standards. It is a housing law like any other. One provision that exists in there in the bill is a process or pathway by which a local government may request an exemption by the Housing Accountability and Production Office from that statute, provided they demonstrate that they have a local process that kind of meets similar objectives that the process prescribes. And we actually had a former open forum on this. We actually recorded that. That's available on our YouTube channel for anybody who's interested to learn more about kind of the specifics around that process. But this process is not about that particular exemption process. That's already underway. We have a dashboard that kind of shows where different local governments are at in the process. we also have guidance that kind of articulates, how local governments apply for that type of thing. However, adjustments in relationship to, ensuring that adjustments are being processed as required by Section 38 and 39 of the bill. That is an example of a housing law that could, say, undergo either informal or formal process. Does that
Thanks,
help?
Sean.
Yeah. Okay.
Yeah, I think that was a great response. And more information on the mandatory adjustments and exemptions can be found on HAPO's website, and we'll forward along the website and all of that information in a follow-up email. So you can learn more about it as well in those platforms. And I see we have a question from Ashley. It's a two-parter, so I'll just go for the first part right now. But she asks, what does informal guidance mean? And can a local government rely on the guidance provided to it by HAPO when implementing housing laws? I think Ryan might be good to talk about informal guidance.
Yeah, so informal guidance is kind of, it's not a process that is within statute, within the Senate Bill 1537 spelled out as something that's binding. It is kind of a quick response to an inquiry, either from a developer or a local government. So I think our standard disclaimer as far as reliance on information from HAPO is we can spot things potentially with regards to statute or rule compliance, where a local code may be out of compliance or where there may be issues. But ultimately, we advise local governments to consult with their own legal counsel on final determinations on implementing any land use statutes. So, we certainly try to be as clear and direct as possible, but ultimately, as far as it being binding or relying on it, that's kind of a decision for the local government.
Thanks, Ryan. And then Ashley also asks, is there an alternative process if a local government does not agree with HAPO's conclusion regarding there being a violation? And can a local government appeal conclusion, or is that the only path, as in formal escalation or an enforcement order, to kind of dispute that HAPO's decision?
And Sean, did you have a clear thought on the response to this one, or do you want me to handle it?
No, feel free.
Okay, all right. I think this is kind of similar to the question we had earlier about kind of a dispute of, and there's not really a process outlined within the statute for a local government to be able to appeal something from HAPO. But again, there will be multiple points where HAPO would be engaging with the local government to discuss the issue, find out more information. In those instances that we all hope are very seldom and far between, that it does go to an escalation, the local government would certainly have all of the abilities through those processes, whether it's an enforcement order, circuit court, or LUBA appeal, to present the case that they have regarding whatever was the basis for the violation through those channels. But that's, I think, kind of how those things would play out.
Thanks, Ryan. Anything else to add, Sean or Joel, on that topic? No. Great. I think we can continue working through these questions and go to Solly. And they ask, if the city I work for is in the process of updating the land use ordinance book, would Section 38 eligible development and design standards, namely 4A, count against the setback requirements as per a variance request, or how would that work?
Hey, Kieran, I'll just note some of these questions are actually about the mandatory adjustments. We did have a webinar on that a couple months back. We'll respond to this in maybe a follow-up with like written responses for mandatory adjustment related questions.
That's a good call. Thanks, Sean. And then Missy asks, are these procedures going to be codified into agency rules according to the APA's requirements for rulemaking? I think Joel, you might be a good one to ask.
Thanks, Kieran, and thank you for this question. So our work is not navigating a formal rulemaking process at this point in time. And part of our real focus is to have these opportunities for collaborative engagement with interested parties and to be able to navigate in a timely fashion that allows us to be operational come July 1. So at this point, we are not focusing on a formal rulemaking process for HAPO.
Thanks, Joel. And Sandy asks about developing model codes and is curious if we're going to develop model codes. And specifically, they're interested in code language for floodplain management. And they adopted DLCD's most recent model floodplain ordinance through a current DLCD funded code audit. And they identified language that is not clear and objective. And we'll need to adopt a new floodplain ordinance with PICM or through an adoption of floodplain maps that FEMA has prepared for our region. And they're wondering if DLCD has language ready, we can rely on those updates. And Sandy, I would recommend reaching out to us over email. And I think we'd be happy to answer this question over email with some more information, unless someone else has anything else to say. Great. Then Missy asks, what is the legal resource for an unsuccessful complaint to have a decision reviewed?
And I'll take a shot at this one, but we can follow up, Missy, if the response here isn't on point. But so legal recourse for an unsuccessful complaint. So I'm presuming that this is from the standpoint of a housing developer who's filed a complaint with HAPO, but that it's not being addressed or is not found to be a violation. If there are, I guess there's other avenues as far as appealing it or appealing a decision within a local framework. So if it's a type 2 decision, for example, having it appealed up to a planning commission or a hearings officer might be one recourse. But as far as the statute in Senate Bill 1537, there's not really an additional process for either a local government or a developer to kind of appeal the decision of HAPO once that's been issued. So again, we do want to have as many points of contact and communication as possible so that there's a chance to address issues, get information, all those sorts of things. But that's kind of what I'm coming up with for a response on that, but we can follow up if that's not really on point.
Thanks, Ryan. So I think for the sake of time, we're going to try to go through the questions that have their hand raised, and then we'll go through some of Sean's slides that talk about HAPO's funding resources and technical assistance, and then we'll come back to everyone else's questions after that. And also we'll, if your question isn't answered during this open forum, we'll make sure to follow up via email after, and feel free to reach out to the HAPO email as well if you have additional questions. And yeah, thanks for the flexibility with managing this format and trying to get to your questions as best as possible. So I think Tim noted that you were on the phone, and I only see one phone number in the attendees group. So I hope by pressing allow to talk that works for you. And I think I pressed allow to talk for Tim. But if that's not working, feel free to email us or contact us by phone if that works best for you. I think just for the sake of time, maybe we'll move on to Justin. And I think I pressed allow to talk, so let me know if that works for you, Justin.
Yeah, can you hear me now?
Yeah, that's great.
So this may not be a question you can answer, but it's one I want to at least put on the ask the group and see if it might just be something that can be dealt with later. But I mentioned this to Tony about a problem I was having in a city, and I realized it sounds like right now HAPO's kind of jurisdiction somewhat is building code or land use related, but I don't know if there's any avenue where HAPO can somewhat mediate issues with cities on other building related issues. We have a particular issue in the city I'm working in where we're having a particular challenge with one of the utilities, not one of the city utilities. And honestly, I have zero places I can turn. It's been a big challenge, and it feels like something that, because it is definitely hampering our ability on some middle housing projects we're working on, and in a particular utility that's city controlled that is not being particularly friendly to middle housing. But it doesn't feel like that we have any place that we can go with that. And even if it was just to weigh in and be some type of an arbiter or a mediator, I don't know if that's something that HAPO could do now or in the future, but it would be really nice if it could be. So I kind of want to throw that out there.
Sharon, if I could jump in real quick here. Yeah, thanks, Justin. And I think that's something that Joel and I have, briefly discussed, the ability to possibly do that. Really, what we're going to lean into is that those Section 5 reports and possibly the outcomes from that, where we have process improvement, mechanisms and methods to inform future policy through possibly legislation. But we're always willing to help wherever we can. And if you want to follow up with me about this, I can loop Joel in, and we can see what we can do to engage that local municipality on it a little bit further.
Does anyone else on the team have anything else for Justin? And thanks, Tony, for the response. If not, we can move on to Jennifer. And I've given you permissions to unmute. Maybe Jennifer's away from the computer, and no worries, we can always follow up via email after the webinar. And I think just for the sake of time, Sean, feel free to take it away with your section of the presentation.
Yeah, sure. Great. So we can move on to the next section. So this is the second component of the overall kind of policies and procedures for the Housing Accountability and Production Office. And this is around kind of technical and funding assistance. And so I'll set it up with a little bit of context and kind of describe how that kind of plays out, at least in the document that we published last week. So as Ryan was covering, right, there's this kind of emphasis and principles that are built into a lot of the policies and procedures that were provided in the previous slides, especially around the idea of kind of connecting local governments with the resources that they need to address compliance with housing laws, to support any efforts to kind of reduce barriers to production, and of course support reliable and effective implementation of all those different types of things, right? And so the context of this document is essentially the legislature, to kind of support that, provided an appropriation to DLCD as part of the Housing Accountability and Production Office, $4 million in Senate Bill 1537 to do just that, to provide technical assistance to local governments, right? And this is something that this request came at a time when a lot of local governments had actually requested kind of code assistance to do things to reduce barriers to production, to comply with housing laws, that type of thing. And so in this biennium, we have kind of allocated about 1.8 million of that to those projects that had kind of requested assistance in the 2023-25 biennium. But we will have essentially $2.2 million kind of remaining at the beginning of the next biennium, the 25-27 biennium. In addition to that, there is kind of an anticipated, I think as mentioned, it depends a lot on what the legislature decides to do, but there is a kind of requested $3.5 million recapitalization that the legislature is weighing right now as part of the ongoing legislative session. We'll have an answer by the end of this biennium as to whether they fund that or not. But assuming they do, in the 25-27 biennium, we would be expected to have $5.7 million for the purpose of providing technical and funding assistance around things like compliance with housing laws. This is in addition to the funding that Mari and Ethan kind of mentioned at the top of this around kind of housing planning, that type of thing. This is a bucket of funding that has some overlap with it, but is a little bit more focused on kind of specific things. If we can move to the next slide. So one thing to know about this is funding is prescribed a very kind of specific purpose. We're only allowed to spend this money in certain ways according to the bill. And importantly, there's limitations on who's able to access the funding and for what they are able to spend this money on. So that is limited specifically to local governments, and it's specifically to do one of three things. One being kind of compliance with housing laws. I think as kind of Ryan outlined, a big emphasis of this program is connecting local governments to ensure that they have the resources to, say, comply with housing laws where, say, a violation is identified, or if a local government identifies a violation that they want to address themselves, right? So that's a very significant core part of this funding. But there's two other buckets of how this money can be spent that aren't necessarily just compliance related, that relate to kind of permitting and land use barriers to housing production. Obviously, codes can touch things that are not necessarily about compliance with housing laws, but can create barriers to the production of housing. And then similarly, of course, the implementation of whatever standards or procedures that relate to residential development. So maybe like the processes that we go through to permit residential development. And so the funding can also be spent in these ways too. But these are kind of limitations. We are not allowed to spend money that don't do these things and are for local governments. So that's just something to keep in mind. If we can move to the next slide. So when you kind of take this eligibility, you take this funding and kind of its dedicated purpose. Basically, the way that the document kind of outlines is there's really kind of three major ways that you can kind of spend this funding, or we put them into three major buckets. On the left-hand column here are those buckets, as well as a couple of examples of what that would include. The first one, I think, is very straightforward. It's what we're calling compliance assistance. So, in response to, say, a formal complaint, or in response to a local government identifying potential compliance issues in their code, this is essentially a pot of funding that is dedicated precisely for housing law compliance, right? And it could take the form of, a compliance agreement, or, a response to an identified violation, that type of thing. Recognizing that there's a little bit broader of a universe than just compliance, we have the second bucket that we're calling supplementary assistance. This is projects that extend outside the boundaries of housing laws. Examples include, just general kind of code assistance projects. Also the one-time UGB amendment assistance that's part of Senate Bill 1537. As kind of Ethan and Mari mentioned, there's going to be kind of a competitive allocation process that's occurring between June and July to kind of help save local governments, time and not to create extra process for applying. This funding source, or this supplementary assistance bucket, is going to be kind of a part of that overall process. So local governments can simply submit their applications to the housing division. And of course, we'll be considering those requests alongside them. So that way we can provide supplementary assistance to local governments as well. And then there's a third bucket. This is a much smaller bucket, but it's around kind of education and guidance. So basically, we have this role around kind of developing other resources for local governments, including things like model codes. I believe there's actually a question in there related to model codes, as well as other guidebooks that are necessary to help local governments, say, comply with housing laws or access resources, that type of thing. So this is going to be a much smaller bucket in comparison to the other two, but can be, for example, right, we can maybe produce different model codes that can help local governments comply with different areas of housing law, things like that. And that's essentially the three ways that we could spend this funding. So as mentioned, it has to meet the eligibility requirements in statute. This is kind of like a little bit of a filter about like what we can and cannot fund, right? It has to be for certain entities and to do certain things, as we've discussed in the previous slide. But after it kind of goes through that first filter, there's a question about, okay, well, how do we prioritize different kind of resource requests that we receive as an office? On this rightmost slide, we have these kind of two different buckets of prioritization. I kind of blow these out into another slide, actually, if we can move forward one so I can describe this in a little bit more detail. Emily, can you move to the next slide? All right. So these prioritization criteria is kind of in the bill itself in Senate Bill 1537. It kind of prescribes one priority that the HAPO is required to adhere to, and that is that we are required to prioritize voluntary compliance with housing laws. So as mentioned, if we have, say, response to complaints or identified by local government potential violations of housing laws, the first priority of how this funding is to be spent is on kind of helping the local government, connect them with the resources that they need to comply with housing laws. So that's already prescribed by statute. But beyond that, right, there's kind of a question about what about those projects that aren't necessarily just about compliance with housing laws? How do you prioritize those, right? And so what the document outlines is actually a separate statutory requirement that is applied to DLCD, essentially just translated into kind of three things that are easy to understand. So this statute is ORS chapter 197A.025. Essentially what this chapter does is it establishes legislative priorities in how the Department of Land Conservation and Development administers housing related rules or statutes. The statute's pretty long. It includes I think around 8 or so different priorities. So we essentially kind of took them and rewrote them, kind of simplified into a context of all right, here are 3 easy understand ways, kind of like priorities that essentially reflect what's in the statute. And basically, they kind of boil down to the first one being that the project kind of unlocks housing funding or capacity. And kind of considering there how many units could be produced by a particular assistance project or affordable units. Are there other state investments that could potentially be leveraged? And of course, does this support kind of innovation and replicability that other local governments would be able to take on to address barriers to production? A second kind of priority that's kind of intrinsic in that statute is around this broader alliance or alignment of different state agencies, policies, programs, and resources to align with Goal 10 housing planning work that local governments are taking on, right? So as part of the kind of Oregon Housing Needs Analysis Program, local governments are doing Goal 10 planning that includes housing capacity analyses, housing production strategies, urbanization efforts, including the urban growth boundary amendments. And so generally speaking, where we have the ability to align with those efforts that local governments are undertaking as part of Goal 10 implementation, we prioritize that. And then the third one, I think this one's pretty intrinsic and something that we've been kind of considering and talking about a lot is, well, what are the resource and capacity needs of different local governments? Obviously, different local governments have different resource needs and constraints that they face. We want to absolutely consider that as part of the process. And we should also consider how are we ensuring our resources are spent effectively? Is there due diligence that's going into different funding requests? Is there readiness to undertake projects? Is there leverage, right, to ensure our funding's being spent effectively? And then, of course, just considering the severity or complexity of issues that we're facing, right? Obviously, complex issues take more resources in order to be able to address. So all of these are considerations and kind of wrapped into this statute that directs DLCD to administer rules or statutes in this way. So with that in mind, that's essentially, kind of the overview of what this document outlines, and I'm happy to dive into question and answer.
Great, thank you, Sean. And yeah, I think we should just hop right into some more Q&A as we only have 15 minutes left. And Tim, we're going to try to answer your question over phone, so we'll come back to you. Can you confirm that your number is the 503-334-1894 just in the chat? And while you're doing that, I will answer another question through the Q&A function. So Clinton asked, I would really like to hear an example of the sort of complaint HAPO will address. There's a big difference between adopting a model code and using a building permit. And I think maybe Ryan, you could give an example of a land use inquiry or complaint that HAPO addresses, and then maybe Tony could talk about an example building codes one, if that would help answer this question.
Sure. Yeah, and thanks, Clinton, for the question. Given the broad range of statutes that are within the housing law definition, it's kind of tough to provide a really broad overview, but sometimes it can get down into the particulars of like how does the middle housing model code apply if there's particulars about infrastructure within a courtyard or those sorts of things that either a developer or a local government may have a question about, and there could be the developer may think that it should be allowed, and the local government may have some provisions where they don't think it's allowed. That might be something just as kind of a random example, getting into those sorts of details. So yeah, I think it'll kind of depend, obviously case by case basis, but yeah, we envision there'll be some of those very case specific, development specific details where we're really having to dive into the particulars of what development is proposed and what the land use codes that are being applied to it are. And Tony, I'll turn it over to you for a building code example.
Yeah, thanks, Ryan. That's a great example. And, a couple of the informal examples we've provided guidance on so far together, HAPO BCD and HAPO DLCD. Some of them have been where there was, a land use layer and then also a building code component to it. There are a couple of questions come up with service utilities to multi-unit buildings. We had an issue that came up like that. From just purely the building code side, we field a lot of inquiries. We didn't get any new authority under 1537, so we're basically, providing very similar, consistent technical assistance as we did previously. And so a common example is, let's say our new attached stack 2-family dwellings, which are allowed now under the residential code, which is a pretty cool thing. We have a lot of questions about those. How can they be configured? How many are permitted to be attached before sprinklers are required? What type of sprinkler system is required once they're required? Those are just a few examples. And then you could go through, permit application completeness, submittal documents, all of those things. So hopefully that helps there, Clinton.
Yeah, thank you, Tony. I think we can move on to Roseanne, and thank you for the question. I see you ask, what if any prescribed timelines will be in place along the way in the point of an inquiry? Example, what are the sub timelines within the minimum 60-day timeline from initial inquiry? I think, Ryan, you'd be great to answer that.
Sure. Yeah, thanks for the question, Roseanne. Within the materials that were posted on the website, I think we have some kind of business practice expectations for some of those review steps. So like the credibility review and the investigation phase, where we may say our goal is to try to respond within 5 days to a particular phase, or within a week once we enter an investigation or something like that. So those are things that are within the policies and procedures, but those are not based on anything in statute where it says HAPO has to complete this phase within a week or 2 weeks or anything like that. So really, I think the only thing that's in the Senate Bill 1537 that is a statutory timeline is that 60-day thing, and then the rest of what's in those materials is kind of our business practices or expectations for responding to things in as expedient a fashion as we can.
Thanks, Ryan. And Tim, we'll give it one more shot to try to answer your question over phone. So I've pressed unmute for you. So try to talk if that works for you.
Hi, can you hear me now?
Yeah, we can.
Okay, good, thank you. Good afternoon, Joel, Sean, and our attendees. My name is Tim McCormick of Housing Alternatives. I noticed that in the enabling legislations and in later communications that there's kind of a apparent limitation of right of action to local governments and local developers in ways. And I wondered if you could offer any background on why you think that was done, or in any case, what would recommend that? And then like where or how advocacy groups, local, regional, or state might be involved given that constraint. Thanks.
I might not be understanding the question all that well. So are you referring to the private, like there is a provision in the bill that prevents the HAPO from, say, proceeding with an investigation where a developer, say, decides to appeal a decision, right? The HAPO is only involved in kind of certain limited ways after that happens. Is that what you're referring to?
Right.
Yeah,
well,
so-
I saw that, and that may be related, but it's a more general point that, there's various points where it kind of specifies, local governments or local developers as eligible parties to take certain steps. And I'm trying to assess like how that's defined and how concretely it would limit anyone else's action. Does that make sense?
I'm not sure that I understand that. Ryan, do you understand?
I'll take a shot. And are you,
okay,
Tim, referring to the portion where it's saying that for a complaint to be filed to HAPO for housing law violation, if it's for a specific development, it needs to be from the applicant, and then for broader violations that it can be from residents of the jurisdiction that can file that? Is that the section?
I guess so. I don't have my finger quite on the points. I just kind of recall observing it at a number of points. But I guess we could go with that point since you mentioned it anyway. I guess, by the way, maybe as context, I should just note that I worked in the past a lot on California's equivalent program, RHNA, and in that context, we worked a lot with the State Housing Accountability Act, and it had notably a relatively broad right of action, which was important, for example, for the YIMBY movement. So I'm kind of, in a sense, trying to assess, like, is it similar here, or is it more constrained, or what? From what you just said, I think it might be similar, because if any local resident has the right of action, that would sound similar to California HAA. But.
Yeah, so I mean, I think we've kind of used the term, if it's a broader patterns and practices sort of complaint that can be brought more broadly by somebody who's a resident in the community. But if it is related to a specific development action or development application, then statute does say that it needs to be brought by the applicant in that instance.
Okay, right. Okay, all right, thank you.
Thanks, Tim and HAPO, for responding to that question. We have another question from Glenn, and Glenn asks, will cities and counties be incorporating the mandatory exemption standards into their codes? And we have guidance on how cities should approach the mandatory adjustment exemptions, and I believe we do not recommend that cities alter their codes in any way and refer to this exemption and the mandatory adjustments just by referencing the statute. And Glenn, feel free to follow up with us, and we can send you that guidance document as well. And we have a question from Stefan. Glad you're here. For developers, should DLCD/HAPO be the beginning point for applying for available state funding after the 25-27 budget passes, as well as coordination between local jurisdictions in the state? Or do developers apply directly to varying agencies, then keep DLCD/HAPO in the loop? I think, Lauren, you might be good to answer this question as well, but I think HAPO's role is to help you understand different funding options that could potentially fit for your project or needs. But for anything specific like applications or eligibility, the program managers of those funding sources are going to also be your best bet. And HAPO won't be the organization that you would necessarily like funnel an application through. but happy to collaborate with you all as you're looking at different funding sources and identifying them. And Lauren, if you have anything else to add.
Yeah, I would just add to, like Karen said, helping identify funding sources that could be maybe something you're not aware of or you haven't thought of for your particular project, and then helping do kind of that warm handoff to that agency or that program manager to get more into the details about eligibility, max awards, when funding is available and open as well. So we can kind of help with that collaboration piece, but applications will be program by program basis, and we're not really involved in that process other than just to kind of help you navigate it.
And then we have a comment from an attendee just about the format of this open forum, and thanks for the feedback. It's noted, and we'll explore looking at other options to try to use different formats. And then we have a question from Jessica. If HAPO receives an inquiry or complaint about a local government code and the local government is already in the process of addressing that issue through a code amendment, how will HAPO handle that? That's a great question, and I think Ryan would be great to answer that.
Yeah, and thanks for the question, Jessica. It's a really good question about kind of how we handle those things that are sort of like working their way into compliance. Just sort of off the cuff, I would think that we still might want to handle that through a voluntary compliance agreement, just to make sure that code amendment is carried through. And I think we would also want to ensure that the local government is using the provision in ORS 197-646 to apply recent state statute that may be, or that has kind of superseded local codes. So if the local code is not in compliance with current statute, that the local government is agreeing to apply the code as written. So I mean, I think both of those would strongly point to your going down that voluntary compliance path. It doesn't need to go further into the escalation portion of that process, and would probably want both of those kind of acknowledged in some sort of voluntary compliance agreement. So that's kind of my quick thought on that, but that's a good thought exercise.
Any other teammates have anything to add on that one? If not, I see we have a question from David in the chat, and David asks, how soon is supplementary assistance available for the one-time UGB? And I think Sean, that'd be great.
Yeah, I can speak to that. So the answer is it will be part of the competitive funding allocation cycle that's between kind of June and July that Ethan and Madi just announced. There'll be a webinar on May 22nd to kind of talk a little bit more about that process, as well as I believe in June, they're going to have kind of like a kickoff kind of open forum to talk about it a little bit more. But basically, as part of funding assistance, that's part of the kind of supplementary assistance bucket that we've talked about. We're going to be enabling local governments to just submit their application in one place to the housing division, and we'll evaluate different funding requests from there.
Thanks, Sean. And I know we have 1 minute left. So Joel, do you want to maybe close us out? And for all the questions in the chat, I think we'll be able to download these and then potentially reach out with more information. But if you don't hear back from us in the next couple of days, please reach out to the HAPO email, and we're happy to answer your questions and collaborate further. But I'll hand it off to Joel.
Kieran, thank you so much, and thank you for helping walk us through this presentation this afternoon. And to all of those who took time out of the afternoon to join us, we much appreciated. Look forward to future engagement with many of you. Please take a moment to keep checking out the resources in our website, as we'll be providing those updates. And as Kieran mentioned, register for or save that email address that you can be in touch with us on. You can also register for Gov Deliveries, which is future important announcements coming from our office as well. Again, thank you to the team for helping on this presentation this afternoon, and thanks to all of you who were able to attend and be here with us. Have a great rest of your day.